Call case number CCD 30 of 2018, the state versus JG Zuma and one other.
I was requested to furnish reasons for the order which I made on 20 March 2024, dismissing Mr. Zuma's application for the removal of Mr. Downer as public prosecutor in order to enable Mr. Zuma to bring an application for leave to appeal. The request was allowed and the reasons now follow. In paragraph 100 of his founding affidavit, Mr. Zuma premised his request for the removal of Mr. Downer as public prosecutor on 4 pillars, namely A, the private prosecution of Mr. Downer; B, the nature of the charges leveled against Mr. Downer, described as the information leaking incident of 2021; C, the nature of the charges pertaining to the 2008 information leaking incident; and D, further and additional considerations which also have the effect of disqualifying Mr. Downer. Most importantly, in paragraph 101 of his founding affidavit, Mr. Zuma stated that any single one of the above mentioned grounds will be enough to justify the granting of the relief sought. He proceeded to state that cumulatively, all these grounds provide an insurmountable hurdle for Mr. Downer's intended continuation in the role of the lead prosecutor and/or prosecutor in the public prosecution. I begin with Pillar 1, the private prosecution of Mr. Downer. Mr. Zuma's request for the removal of Mr. Downer as public prosecutor is anchored on the private prosecution of Mr. Downer. It was argued that if Mr. Downer were to prosecute Mr. Zuma today and then be prosecuted by Mr. Zuma the next day, the society will make a mockery of our justice system. If that were the position, then I would not have hesitated to grant an order removing Mr. Downer as the public prosecutor. But that is not the position. As things stand, there is no private prosecution. All attempts by Mr. Zuma to prosecute Mr. Downer have been unsuccessful. I might just add that as at the date of the hearing of argument in the present application, the Supreme Court of Appeal had already made a factual finding that the attempt by Mr. Zuma to prosecute Mr. Downer amounted to an abuse of process. The Supreme Court of Appeal held as follows, quote, "The facts demonstrate that the private prosecution of Mr. Downer is an abuse of the process of the court for multiple reasons. First, as the High Court found, it was instituted as a further step in a sustained attempt by Mr. Zuma to obstruct, delay, and prevent his criminal trial. This is an ulterior purpose, and the institution of the private prosecution was accordingly unlawful. Second, it was instituted in order to have Mr. Downer removed as the prosecutor in Mr. Zuma's trial. This too is an ulterior purpose, which renders the private prosecution unlawful. And third, the contemplated private prosecution is patently and hopelessly a hopeless case. It is obviously unsustainable. Mr. Zuma has not made out a possible basis on which Mr. Downer might be convicted, even in Mr. Zuma's own version of the facts. This, too, renders the private prosecution an abuse of process." Close quotation. C. Zuma versus Downer and another, square brackets 2023, ZASCA 132, square brackets 2023, all SA 644 SCA, paragraph 11, hereinafter referred to as the SCA judgment. Pillar 2 relates to the alleged leaking of Mr. Zuma's private and confidential information to Ms. Moore. It was argued on behalf of Mr. Zuma that the fact that Mr. Downer is facing a serious charge of disclosing the confidential and private medical information of Mr. Zuma to Ms. Moore in breach of Section 41(6) of the National Prosecuting Authority Act 32 of 1998 disqualifies him as a prosecutor in the present matter. Firstly, Mr. Downer denied having disclosed Mr. Zuma's medical information to Ms. Moore. And secondly, the issue pertaining to the release of Mr. Zuma's medical information to Ms. Moore was thoroughly canvassed by Kun J in a removal application brought by Mr. Zuma in terms of Section 106(1)H of the Criminal Procedure Act 51 of 1977. In his judgment, Kun J found, as an undisputed fact, that Mr. Downer made no such disclosure to Ms. Moore. CS versus Zuma in another, square brackets 2021, ZAKZPHC 89, square brackets 2022, 1 all SA 533 KZP, hereinafter referred to as removal judgment. A similar finding was arrived at by the full court. Of this division. This finding was again confirmed by the Supreme Court of Appeal. It is important to note that every attempt to overturn Kun J's judgment has been unsuccessful. Findings made in the removal and private prosecution judgments are binding on this court. I now turn to deal with Pillar 3, the alleged leaking of information to Mr. Sam Soul. Again, this issue pertaining to the conversation between Mr. Downer and Mr. Soul has been dealt with several times at various litigation stages. Firstly, it formed a part of the spy tapes which were utilized by Mr. Zuma with the view of persuading the then acting National Director of Public Prosecutions, Mr. Mshe, to withdraw the charges against Mr. Zuma during April 2009. It again surfaced before Kun J. It was again dealt with by the full bench of this division and ultimately the Supreme Court of Appeal. In his judgment, Kun J made a finding that Mr. Zuma's accusations were, quote, based on speculation, unsupported by admissible evidence, close quotations. It is important to note that Mr. Downer, in his answering affidavit, disputed having disclosed any information to Mr. Soul relating to Mr. Zuma's case. In paragraph 118.5 of his answering affidavit, he pointedly stated, and I quote, I merely described in the abstract the mechanisms by which the NPA obtain mutual legal assistance, close quotations. It is worthy to be noted that in response to the above, Mr. Zuma merely stated in paragraph 97 of his replying affidavit, and I quote, here it was Mr. Breitenbach who initiated the conversation to achieve his own ends or those of the prosecution team. Mr. Downer joined into the enterprise and willfully associated himself with its criminal objective. In any event, the remarks of Kun J relied upon were not directed at the matter involving Mr. Soul. My emphasis added, close quotations. Pillar 4 related inter alia to Mr. Downer's indispensability. In argument, Mr. Mpofu submitted that Mr. Downer is not indispensable and added that if he were to be removed as a prosecutor, the defense will be ready to instantly proceed with the trial. This argument is not supported by the evidence. In paragraph 159 of his founding affidavit, Mr. Zuma stated, and I quote, it is, in my opinion, also very doubtful whether the current members of the prosecution team who have been inextricably involved in the current legal prosecution will qualify but that is not an issue which requires the adjudication of this court at this present moment, close quotations. In response, Mr. Bartlander argued that the question for determination is whether our system allows an accused person to abuse the process by electing the prosecutor of his or her choice. He proceeded to say that if such a process were to be allowed, that will become a standard tool in the toolbox for well-resourced accused persons to abuse the process. He further expressed the view that our law does not tolerate such process. There is merit in that argument. Mr. Downer advanced numerous practical reasons why he should be retained as a public prosecutor, including the complexity of the matter, preparation for trial, availability of suitably qualified prosecutors, and the financial prejudice to the state. See Mr. Downer's answering affidavit, paragraphs 82 through to 93. It is worth mentioning that except for reiterating that Mr. Downer is not indispensable, Mr. Zuma did not deal with any of the above reasons in his replying affidavit. See Mr. Zuma's replying affidavit, paragraphs 75 through to 79. To conclude, I am satisfied that there is merit in the submission that the grounds advanced by Mr. Zuma were sufficiently dealt with in previous litigation. In his own words, Mr. Zuma stated in paragraph 160 of his founding affidavit that he is aware that some of his atmospheric issues had already been dealt with in previous litigation, albeit in pursuit of different causes of action. He concluded by stating, and I quote, "Whichever way they may have been construed in such previous litigation, they are now invoked merely to demonstrate that the overall atmosphere is sufficiently poisoned and too toxic to permit for any fair trial if Mr. Downer is or remains a prosecutor in the public prosecution brought against me." Having considered all the grounds relied upon by Mr. Zuma, both individually and cumulatively, I was unable to conclude that Mr. Zuma's right to a fair trial would be violated if Mr. Downer remained the prosecutor in the matter. Those are the reasons for the order I granted on 20 March 2024.
My Lord, in anticipation of what happens now, my learned friends and I for the state have been in discussion as to a timetable, because we're now proceeding for the actual application for leave to appeal against the second removal application, against the dismissal of that application. So, my Lord, for your Lordship's convenience, I have typed up a timetable which you could hand up. Sorry, could you? And this takes into account the availability of counsel for all the parties. My Lord, if we could start off with the dates for the hearing, given the availability of counsel for Mr. Zuma and counsel for the state, we propose that...
Is this the date for the hearing of the application for leave to appeal?
The actual hearing, yeah, the last paragraph there. It's 25, 26 or 27 November and 4, 5 or 6 December.
I won't be available.
My Lord?
I won't be available then.
Or the 4th, 5th and 6th of December.
I'm not going to be available during the course of this year for the remainder of the... I'm not going to be available in January next year.
In January of next year?
Yes.
My Lord, I'm sure that we haven't discussed that amongst council, but if your Lordship could give us a date, then we would, I'm sure, make a plan. But prior to that, my Lord, we also did discuss a timetable for the exchange of papers, and I think we could stick to that anyway.
Yes.
So that we could get that behind us and get ready for the actual application. And that is Mr. Zuma's supplementary application for leave to appeal based on your Lordship's further reasons.
Right.
The 4th of October, 2024. The date for our supplement satisfactory answer, that is 11th of October 2024.
Right.
Mr. Zuma's heads of argument, the 25th of October 2024, and the state's heads of argument, the 1st of November 2024. I've indicated that that date might be movable depending on which counsel is available. My learned friends for Mr. Zuma have agreed that that might be moved on a week, so it might be the 8th of November, depending on counsel. It's not going to make any difference given the date that your Lordship proposes to give in January.
Okay.
My Lord, we could then discuss the date for the hearing once we hear from the court. My Lord, there is just the further issue that this court has reserved the dates next year of the second and third terms, starting in April and running on then until basically the end of the trial and the availability of the court.
Yes, those dates remain reserved.
Remain reserved, yes. That is, so, my Lord, we will certainly argue that whatever the outcome of any application in January, the state will argue, and if necessary, we'll argue it formally and properly before your Lordship, that those dates in April must remain and the trial must start on those dates, whatever the status of any appeal processes might be going forward. Because no matter what your Lordship decides in January, on the date which the court will then set, obviously, if it goes against my learned friends, then for number one, accused number one, they will take further up the line, in accordance with what we say is Stalingrad, and that this cannot be allowed to continue. And so we will argue that the trial we must all be prepared, our diaries must be open, briefs must be properly issued, preparations must be so that on the date in October, I think it's in April, I think it's the 15th of April, it's in the draft order we previously gave to your Lordship. It's the 14th of April, and the following terms. We will all be ready for trial. The state witnesses will be briefed, the police will be available, the court will be available, and my learned friends, certainly for accused number two, have indicated they're available. Mr. Mpofu, who's not here today, but he has indicated he is available on those dates. And we must make it now clear that we cannot simply carry on moving the trial on to accommodate a long series of appeals, which take sometimes years, up to the SC and the Constitutional Court. So we will argue. And we're happy with that. The Lordship keeps those dates reserved under those conditions.
Right.
May it please the Court, my Lord.
Okay. Can you prepare a draft order accommodating dates mentioned in paragraphs 1.1, 1.2, 1.3, and 1.5, and then leave a date open for paragraph 1.5. That is the date of the hearing. Also, I'm going to adjourn for a moment and discuss a date with the Judge President, because I don't even have a roster for next year.
As it pleases the Court.
Right. Mr. Buthelezi?
The Court pleases. Thank you, Madam. With the exception of the submissions on the dates, we obviously now have to take exception to the proposal that the dates for next year, April, remain reserved, simply because of the absurdity of the proposal. If already we can anticipate that we will argue the application for leave to appeal, not the leave to appeal, application for leave to appeal, in the first quarter of next year. What purpose is served if we can then enroll a matter that is, for all intents and purposes, from what we can anticipate, will still be the subject of an appeal come April next year? And for them to say, I mean, so casually, glibly, starting crowd, we know that we take exception to that because we are exercising our rights. So it's no creation of ours that this application is now going to be heard at this time of the year. Judgment was granted in March. Okay, so we'd never created that circumstance that causes the reasons to be given in September. So I think it would be prejudicial to the court to keep blocking those dates when we know now, as a matter of fact, we may have those holding dates, but to block out 2 terms is prejudicial to counsel, because Mr. Dana can't explain how it could happen that while the matter is being appealed, whether that leave to appeal is granted or denied, the appeal avenues that exist in as far as petitioning the SCA and petitioning further make it unfeasible that we would sit here with good mind and good conscience and assert that we're going to start the trial at the start of April next year. That's not pragmatic and that's not possible. So I'm not too sure whether the court can be cornered into putting that in an order. As we previously did it with your brother, Justice Khulu, we would have some dates, because we could not postpone the matter sine die, to come back and postpone the matter or update the courts. And then only once that certainty is ascertained can we then go back and say, because there's counsel for the second accused and ourselves as well, involved in other matters, to now have in September this year a commitment that says we're not available from the second time, when we already know that yourself, my lord, is not going to be available at the end of this year to hear this appeal. So we're already in Q1 of next year. So that's the only point, my lord. Other than that, we're okay. We just, in as far as the date of next year is concerned, our proposal is the second week of February for the hearing of the application for leave to appeal. Because
January, Mr. On the first
my leaders, I'd have to
date, Mr. Buthelezi.
Well, end of January, my lord.
Right.
We were not chips hands. We were just putting the proposal on the table. Other than that, everything else was by mutual agreement, madam.
All right.
Thank you.
That's fine. Right. We'll stand adjourned, and I just want to consult the Judge President with regards to the dates that are available, because we don't even have a roster for next year. James.